This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about what happens when an insurance agent controls actions of a broker and the insured complains about the coverage obtained because there is no right to sue a broker who does not provide a special relationship to the insured with regard to the acquisition of insurance. Plaintiff Green Technology Lighting Corporation appealed the order of the District Court for the District of Idaho granting summary judgment in favor of defendant Kraus and Associates Insurance Services of Northern California. In Green Technology v. Kraus and Associates, the United States Court of Appeals for the Ninth Circuit on September 20, 2024, resolved the dispute over the existence of a special relationship between an insured and its broker. The District Court granted summary judgment to Kraus on Green Tech's claim of negligence and broker malpractice for two independent reasons. First, the court held that the Kraus did not owe Green Tech a duty of care, an essential element of negligence claims under Idaho law or just about any other law. And second, the court determined that the Idaho's economic loss rule bars recovery for any negligence committed by Kraus. Idaho prohibits the recovery of purely economic losses in all negligence actions. A purely economic loss is one that is not connected to an injury to a person or property because the economic loss rule limits the actor's duty so that there is no cause of action in negligence. Summary judgment is only appropriate in cases where the rule applies. Green Tech alleged only economic losses connected to the recall of its products. Unless some exception applies, Green Tech has no cause of action for negligence under Idaho law. Idaho generally recognizes two exceptions to the economic loss rule. One, where a special relationship exists between the parties, or two, where unique circumstances require a reallocation of the risk. The district court concluded that neither applied to Green Tech's case. The special relationship exception is extremely narrow and applies in only limited circumstances. Idaho recognizes two situations in which a special relationship has been held to exist. One, where a professional or quasi-professional performs personal services, or two, where an entity holds itself out to the public as having expertise regarding a specialized function and by so doing knowingly induces reliance on its performance of that function. The Ninth Circuit concluded that neither situation fit the facts of this case. The district court correctly held that although Kraus was a professional insurance broker, it lacked the custody or control over Green Tech's insurance coverage that would justify recognizing a special relationship giving rise to liability. Kraus did not have ultimate authority over which insurance policies Green Tech obtained. Rather, it was Insure Idaho, Green Tech's insurance agent, that instructed Kraus to bind the policy with less coverage than that which Green Tech thought it needed. Kraus did not unilaterally control the level of liability coverage that Green Tech would receive. The Ninth Circuit concluded there was thus no special relationship between Kraus and Green Tech based on the professional services Kraus offered, nor did a special relationship exist due to Green Tech's reliance on Kraus's expertise. This exception requires that an expert have actively sought to induce reliance on the part of the plaintiff, and where there is no indication in the record that the plaintiff relied upon or were even aware of the defendant's provision of its special services, there is no special relationship. The district court found that Greentech had no knowledge of Krause's existence, as it interfaced only with Insurance Idaho in seeking to procure insurance for its business. Greentech failed to raise a genuine factual dispute as to this finding, and the economic loss rule thus prohibited Greentech from recovering from any alleged negligence on Krause's part. Assuming that Krause owed some duty of care to Greentech in how it performed its brokering services, the Ninth Circuit agreed with the district court that the economic loss rule was fatal to Greentech's negligence suit. In my opinion, the economic loss rule prevented a suit against a broker who had no relationship with the insured but only contact with the insured's agent, since the broker acted basically as an order taker for the insurance agent and provided no advice or counsel to the insured, nor did it hold itself out as a specialist giving advice to the insured. There was insufficient contact with the plaintiff insured to allow it to maintain a suit because the economic loss rule existed, and since the plaintiff only lost money. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog, and you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and access to the more than 4,850 blog posts. You can also subscribe to these videos. They're also free. And if you do, I'd appreciate it if, as you watch the blog video, that you click on the like button on YouTube or the thumbs up button on rumble.com. Please also tell your friends and colleagues about the blog and these videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.